Next matter to come before the court this morning is Appellant Roy Young Jr. versus State of Ohio. Each party will have 15 minutes in which to present their case. The appellant may retain up to 5 minutes for rebuttal if you're the appellant. Please let me know when you come up to the podium. I'm keeping track of the clock. Keep your five for passage of time. We are being recorded to be posted online, so please try to maintain that podium as much as possible. We have read your briefs and we're ready to proceed with one.
Thank you, Your Honor. May it please the court, I'm Jack Bradley, and I represent Roy Young, who's currently serving a life sentence in prison for rape. The allegations in this case were that he engaged in sexual conduct with the daughter of his wife, and the testimony in the case relied almost exclusively on her testimony. There was no actual physical evidence, although there was a condom wrapper that was recovered. That condom wrapper was tested. It was inconclusive as to whether or not Roy Young's DNA was on that condom, and also inconclusive as to an unidentified male's DNA was on that condom. The unique thing about this particular case is that the alleged victim indicated that each time she engaged in sexual intercourse with Roy Young, that Roy would use a condom, and that he would then flush the condom down the toilet. So Detective Rico from the Lorain County Sheriff's Department was assigned to investigate the case. And as part of his investigation, he went over to the Young residence and looked into the septic tank. And when he looked into the septic tank, he saw floating on the surface of the septic tank condoms and condom wrappers. He said that he consulted with his supervisor and also someone from BCI, and it was indicated to him that the septic tank was a hazmat situation, and that anything that he would remove from that septic tank would be contaminated. So he decided not to remove anything from the septic tank, and he attempted to take photographs of what he observed in the septic tank. The problem was that the camera that he was using was not taking very good pictures, so when he got back to the Sheriff's Department, he realized that the pictures did not develop properly. He made no effort to go back and rephotograph the condoms and wrappers that he saw in the septic tank. My argument in this case is that his attorney, Mr. Young's trial attorney, did not challenge whether or not the condoms or the wrappers that were found in the septic tank had any evidentiary value. So when I was contacted by Mr. Young's family, I retained a DNA expert and asked the expert whether or not these condoms could have been retrieved to see whether or not there was anything of evidentiary value in the condoms. Because a condom is a receptacle for semen, and we would expect that there might be semen inside a used condom. So the jury was left with the impression that since the septic tank was a hazmat situation, that these condoms would not have any evidentiary value, and therefore the recovery of those condoms would not have provided any exculpatory evidence to Mr. Young, and therefore the jury was left with the impression that there was no error in the detective recovering those condoms.
Counsel, did the expert say that those condoms would have provided something of evidentiary value?
The expert certainly couldn't provide an opinion as to they would, but the expert did provide an expert opinion that you would expect to find DNA in those condoms that could result in DNA that could be associated with a person who had used those condoms. But that was never presented to the jury because the defense attorney admitted that he never contacted a DNA expert and that an expert was never provided to the jury to provide them with that information that if those condoms had been collected, an expert could have then attempted to retrieve DNA from inside the condoms, analyze that, and see whether or not that was Mr. Young's DNA that was in the condoms, or that it may have been the DNA of the alleged victim's boyfriend.
How would you have known it was the DNA of the alleged victim's boyfriend?
Well, you wouldn't, because the defense never asked that the boyfriend's DNA be examined, and I think that has something to do with also the condom wrapper, because there was an unidentified male's DNA found on the condom wrapper, and the jury was not provided with any information as to whether or not the boyfriend's DNA was on this condom wrapper. And so if the defense had asked that Mr. Sittinger's, the boyfriend's DNA, had been retrieved and analyzed, possibly there may have been evidence connecting the boyfriend with the condom wrapper, which may have led the jury to conclude that maybe some of those condoms and wrappers that were not retrieved from the septic system belonged to the boyfriend.
Under what legal mechanism should or could have defense counsel have asked for boyfriend's DNA?
There was unidentified DNA found on the condom wrapper. There certainly could have been a motion made to the court to ask that, since the victim admitted that she had had sex with her boyfriend, that there could have at least been a request made to the trial judge, asking that Mr. Sittinger's DNA be collected for purposes of seeing that that unidentified DNA might have belonged to Mr. Sittinger. That would have been very important, because of the fact that, again, we're talking about a case where the whole case basically is based upon the credibility of the alleged victim.
Your position is that the trial judge would have granted such a motion?
I think so. I think that you want to make sure that criminally accused is given a fair trial. If we have unidentified DNA in a victim who has admitted that she's had sex with her boyfriend, that we want to see if we could possibly identify that DNA that was on the condom wrapper. The whole defense in this case was based upon the fact that the alleged victim recanted her story. And so the defense provided multiple witnesses to testify that they were at a party at a lady's house by the name of Katie McSherry. And so they all testified that they were at the house, there was a party going on, and that the boyfriend had a phone call from the alleged victim, and that he put this phone call on speaker, and she told her boyfriend that she had made up this story, that she didn't know how to go to the police and tell the police that she had made up this story, and that she was confused now because she thought she might get herself in trouble because she had made these allegations against her stepfather.
We haven't read the transcript of the trial, we read the briefs that were filed, so I don't know what was testified to, but she did testify.
The alleged victim?
Yes.
Yes, she did.
And was she questioned about all that stuff while she was on the stand?
Yes, and she denied that.
Okay.
And then the defense called these witnesses to basically rebut what she said and to verify that this conversation was overheard by these witnesses at McSherry's residence.
Now that occurred before she testified in this case?
Yes. So, the state of Ohio then called Katie McSherry as a witness in rebuttal. The defense attorney objected to her testimony, but that was overruled. But he did not ask for a recess in order to do any kind of background check on Katie McSherry. He also didn't even take the time to run a background check to see if she had any cases pending in Lorain County Common Pleas Court. As it turned out, Katie McSherry was under indictment for 3 counts of trafficking in heroin. At the time she took the witness stand, she had an ankle bracelet on. Defense attorney said, well, he didn't know that she had a case pending. The prosecutor said, well, she didn't know she had a case pending. And the defense attorney didn't even take 5 minutes to run a check on his cell phone to see if she had a case pending, because it's very important, if you have the most important witness in the state's case to rebut your defense, that you find out whether or not this witness might have a motive or an incentive to testify for the state of Ohio.
Did I understand correctly that Ms. McSherry was on the defense witness list also?
Well, I don't know if she was on the defense witness list, but she was certainly mentioned during the defense case because the witnesses for the defense testified that they were at this party at Katie McSherry's. And I think I have the place in the trial transcript where that was actually,
While you're looking, are you retaining any time for rebuttal?
yes, you could, I could.
How much? You're at
3 minutes?
Just under 5 minutes right now.
Okay, almost done. Yeah, at page 663 of the trial transcript, Mr. Liu, at lines 16 and 17, actually asked Corey Sittinger the name of Katie McSherry during Corey Sittinger's cross-examination. So he knew about Katie McSherry. For some reason, he never even talked to Katie McSherry before the trial to find out whether or not this party did happen at her house. Didn't do any background check to see if she had any cases pending. Didn't ask the prosecutor if she was getting any consideration. And then lo and behold, we find out that Katie McSherry had this case pending, that she was in front of Judge John Moraldi, that at the time of her sentencing, but not at her plea, at the time of her plea she said that there were no offers or promises or consideration given to her for her plea. And at the time of her sentencing, the state of Ohio, the prosecutor got up and said, "Oh, Judge, we're asking for community control. We know that's unusual in these kind of cases. We know you usually send people to prison or at least incarcerate them in the county jail for heroin trafficking charges. But because of her cooperation in a case, we're asking that she receive community control," which she did receive. Even though she said at the time of her plea that she was not offered any promises or consideration, and neither the state of Ohio nor her defense attorney indicated to the court that she had been given any consideration because of her testimony against Roy Young. But ineffective assistance of counsel in this case is that Katie McSherry was never investigated prior to her testimony, nor did the defense attorney file a Brady motion, nor did the defense attorney ask for a continuance so that he could do a background check and at least ask Ms. McSherry if she was receiving any consideration from the state of Ohio. Of course, the state of Ohio says, well, she was not ever offered any consideration for her testimony, but I'm sure that she had some expectation that if she helped the state of Ohio while she had a heroin trafficking case pending, that she might get some consideration from the state. And she certainly should have been asked that, and I think that may have affected her credibility if a jury knew that not only was she trafficking in heroin, but also charged with possession of heroin, which may have implied that she was using heroin. And maybe her credibility might have been affected greatly by the jury in this case. So I think there's ineffective assistance of counsel. I think we've satisfied the 2 prongs of the Strickland test, and I would ask the court to look at the cumulative ineffective assistance of counsel in this case and grant this citizen who's doing life in prison a new trial. Thank you very much.
Good morning, Your Honors. May it please the court, my name is Matt Kern on behalf of Dennis Will, the Lorain County Prosecuting Attorney. I represent the state of Ohio in this matter. I was not brief counsel. I did not author the brief on behalf of the state, but I'm well versed in the issues and more than prepared to go forward today. I hope to do justice to Ms. Guerreri's brief that was very thorough and well researched. Let's start with the issues on the post-conviction petition in the order that they were raised in the brief, and that is first this evidence with condoms from the septic tank and whether or not Attorney Liu should have consulted and called an expert witness in the trial. First of all, I want to jump to the prejudice prong first, if I may. The claim about whether or not Attorney Liu's performance was ineffective requires a lot of speculative assumptions about what that evidence was, how it would have been presented, and what effect, if any, it might have had. And now those assumptions require leaps of faith that are not supported by any evidence in this case. Specifically, We know that those condoms from the septic tank were not collected. We know that from the trial transcript, and we know that from the post-conviction petition hearing that was had. And therefore, we do not know whose DNA, if any, was recoverable from those condoms, and if a profile could have been developed from any evidence collected from those condoms, whether it would have matched any particular person or would have been inconclusive. Because we don't know either 2 or 3 of those things, it is speculative at best to say that Mr. Liu should have done something different, right? For a prejudice prong and an ineffective assistance of counsel claim, this court must find a reasonable probability that the outcome would have been different, or reasonable probability to undermine confidence in the result. We don't know enough facts about these condoms and what evidence existed in them and whose DNA, if any, it was. We don't know enough about that to say with any reasonable probability that the outcome might have been different. You don't have reasonable probability to undermine confidence in the result. On prejudice prong alone, this claim lacks merit. Jump back up to the actual deficient performance prong. What did Mr. Liu do wrong in this case? Here are the following. Here are the additional facts that Mr. Liu testified to during the post-conviction hearing that he was aware of at the time of trial, and why he made the strategy decision not to call a DNA expert or not to go further. Mr. Liu is an experienced attorney, one of the best. He understands DNA evidence, he understands its import in this case, and actually, I would argue, made a better use of the evidence available to him at trial than what Mr. Bradley is suggesting he should have done. Here's some additional information that Attorney Liu had. He knew that the defendant's wife lied to police when she told them that she and the defendant did not use condoms when they had sex. He knew from conversations with the defendant and Ms. Young, Sherry, I believe is her name, he knew from talking to the 2 of them that they did use condoms when the 2 of them engaged in anal sex. So therefore, he believed that there was a substantial probability that one or more of the condoms that were found or seen in the septic tank could have contained Mr. Young's DNA. That would have completely devastated his argument made at the trial court that it was somebody else's, or it could have been somebody else's, right? That would have directly undermined his claim that he was able to make to the jury that, well, the state didn't do enough in this case. Had they actually done that, had he made those claims in a different way, it could have come out that, oh, actually it is entirely possible that is the defendant's DNA in that condom that was observed by Detective Rico. Is that deficient performance, or is that actually the hallmark of effective trial advocacy to make a better strategic argument? Other evidence that Mr. Liu was aware of was that in the issue of the condom wrapper, which I think is what I'm going to call issue 2 with respect to the condoms. I think it's actually the second ground for relief for organizational purposes. The condom wrapper found in the victim's room was in fact collected, it was sent out for testing, and we know from the trial and the post-conviction petition hearing that the results were inconclusive. There was a male profile identified clearly by the presence of a Y chromosome in the profile. We know that that's male DNA. They could not identify it as Roy Young's, but they also could not exclude Roy Young as being a potential contributor. The result was inconclusive, but they were not able to exclude Mr. Young. This actually gives Mr. Liu, the attorney, an ability to make a strategic argument to the jury. Also, Mr. Liu testified at the post-conviction hearing that he was aware from Mr. Young's family in preparing for trial that the family believed that the condom wrapper had been planted by somebody. The implication of that is Mr. Liu had information from the family that they believed that if additional testing were done, that it might exclude the person he wanted to try to blame, the boyfriend, Mr. Sittinger, and could have included, if additional testing were done, could have included the defendant. That would be devastating to Mr. Liu's ability to make a convincing argument and would end, basically, the trial, right? we would have then DNA evidence corroborating the victim's claims that she had in fact not only been raped for a period of years, ranging from the time she was 5 up until the time that she was approximately 15, for a period of 10 years. We would have not only her testimony that those things had happened, but we would have physical evidence corroborating some of the specificity of the nature of how that happened. Right? We would have condom wrappers with the DNA in her bedroom. That would be devastating if you're Mr. Liu, to your ability to make an effective argument and actually try to make an argument to a jury. So Mr. Liu's strategy here in not pursuing a different tack that Mr. Bradley suggests now, with the benefit of hindsight, that we know it wasn't successful at trial, right? Mr. Bradley's suggestion would actually have one of the possible effects could be a complete devastation of Mr. Young's chances for acquittal, right? Mr. Liu's argument about the state should have done more, we don't know enough, it could have been somebody else, it could have been the boyfriend, the wrappers found in her bedroom, we know that she's admitted to you that she has engaged in sex with her boyfriend. That's fine, right? Those are all effective arguments to a jury, right? They explain the circumstances of the offense in a way that is not inconsistent with innocence. They are consistent with a claim that he did not do this thing he's being accused of. One of the effects of proceeding in the way Mr. Bradley suggests would be to actually disprove innocence. Not just undermine the claim of innocence, but disprove innocence. I think Mr. Liu did a remarkable job in that sense of preparing an effective defense and strategizing how to go about defending the case given the evidence he had. In that sense, an inconclusive test result from BCI is far better than a result excluding the one person you think is your possible real offender, right? If the strategy is to try to blame somebody else to explain the presence of physical evidence that was in fact found or seen, and the strategy you develop, per Mr. Bradley's suggestion, is to blame somebody else and the result comes back, it's not them, what are you left with? You're left with a claim by the state that it was the defendant. Mr. Liu did a very, very thorough job in preparing this case and is familiar with DNA evidence. I guess that leaves us with the Katie McSherry testimonial issue, unless the court has additional questions about the DNA or the condoms. Okay. First of all, any claim that Mr. Liu should have questioned McSherry, let's assume for a second that Mr. Liu had been aware of the pending charges against Mrs. McSherry. He would not have been able, under Evidence Rule 609, to ask about that. 609 covers convictions. It does not cover pending charges because, as Mr. Bradley wants to say Mr. Young is in this case, it is possible that somebody charged with the crime did not actually commit the crime. That's why we have trials. Ms. McSherry had not pleaded guilty at the time of Roy Young's trial to any trafficking or possession charges. Allowing Mr. Liu to ask during Mr. Young's trial Ms. McSherry about her pending charges is not supported by the evidence rules. At best, that would be a 608B, specific instances of conduct, which there's no indication from this record, either from the trial or the post-conviction petition, that it would have been applicable. So, ultimately, we're left with information we'll get to. It didn't actually exist and didn't happen the way Mr. Bradley argues. But even if there was consideration, or even if there was some kind of agreement, implicit, tacit, or otherwise, it's not, there's no ability for Mr. Liu to ask that question. Now, arguably it goes to impeachment and motive and all those things, but that's exactly what's covered by 609. And if asked, we'll get to the, now let's just get to the merits. There was no agreement. There was no understanding. There was no tacit, implicit, explicit specifically stated understanding between Ms. McSherry and the state. When Assistant Prosecutor Reed Butler, who tried this case, found Katie McSherry the day before she testified, she was unaware that Ms. McSherry had a pending criminal case. She testified to that in the post-conviction petition hearing. The room prosecutor who was handling Katie McSherry's case testified as well in the post-conviction petition hearing, and testified that at the time that she testified, there was no agreement on her then pending case for testimony or for cooperation or for anything. She didn't plead until after that trial happened. How could there have been an agreement on something that hadn't happened yet? This is the ultimate logical fallacy that I just don't understand from this case. How could there be an agreement on something when it hasn't happened yet? How is Mr. Liu then ineffective for failing to cross-examine about something that doesn't exist? Set aside a prejudice component for a second. How is that deficient performance? It's not. The testimony in this case from the post-conviction petition hearing is, in my opinion, overwhelming. Mr. Liu did a remarkable job of preparing for trial, of organizing the evidence, of preparing for trial, of going through all the evidence, talking to different witnesses, right? Mr. Liu found 3 or 4 or 5 people from this supposed house party who all claimed that they heard the victim recant on the speakerphone call. Now, Ms. McSherry then came back and testified there was no such party. But clearly Mr. Liu was working the case, talking to people, reviewing the facts, and developing a trial strategy by the fact that he did in fact call witnesses in the defense case and organized a consistent defense. He confronted the DNA evidence on the one hand. He confronted the claims of the victim's testimony on another. He dealt with some of the possible issues in a way that was internally consistent with his trial strategy and had the possibility of getting an acquittal for his client on, as Mr. Bradley likes to remind us, very serious charges. Ultimately, I'm always questioning, whenever I see an ineffective assistance claim, what did the defense attorney do wrong? What could they have done differently that fell below an objective standard of reasonableness? I don't know what that is in this case. What did Mr. Liu do that fell below an objective standard of reasonableness? He prepared an adequate defense. He prepared an effective defense. You don't have to win for your attorney to be effective. The attorney has an objective standard of reasonableness that Mr. Liu met in this case. Nothing more was required, and the trial court's finding that Mr. Liu did not err, did not fall below that objective standard, and there is no prejudice from that, is not an abuse of the trial court's discretion, which is ultimately what this court is looking at when assessing a post-conviction petition. You're looking at whether the trial court abused its discretion in making the findings of fact and conclusions of law that it made. Okay, sure, on a legal side you might have a de novo review, but there's no legal question here. We're just applying Strickland. There's no legal question for the court. It's a factual issue, right? So your review is abuse of discretion for the trial court who made factual findings in this case. And on that, unless the court has any further questions, I think that you must affirm the decision of the Lorain County Court of Common Pleas in this case.
I have one question.
Yes, Your Honor.
Of course, somebody always has to, right? In terms of what I'm just going to refer to as the house party and the recantation, did that come up before trial?
Yes. So in the actual trial proceeding itself, not the post-conviction petition hearing, but the trial itself, there were 3 or 4 or 5, I'm sure Mr. Bradley has the actual number, but more than 2, but probably less than 6 individuals who testified at the trial.
Prior to the start of the trial, was that information known? That's what I'm, or
I don't know that it was it probably was not in the police reports.
you just answered my question, thank you.
Yes.
That's what I was trying to get at. So it was not a part of discovery, it was a part of trial counsel's trial work, so to speak, putting on the defense.
I believe so. I'm sure if Mr. Bradley thinks differently that he can correct me if I'm mistaken on that point, but obviously neither of us was trial counsel.
Okay, thank you.
Thank you.
Thank you.
provide to the state of Ohio the names of the witnesses that would be testifying on behalf of defense, including those witnesses that testified about the party at Katie McSherry's. I would direct the court to page 665 of the transcript of the trial, where Mr. Sittinger admits that he received a phone call from Brittany Bias, the alleged victim, while at a party at Katie McSherry's. So even Mr. Sittinger admits that he received this call from her. He does not say that it was exculpatory in nature, but he does admit that he received this call while at a party at Katie McSherry's. Now, if that's effective assistance of counsel, that you don't call the person who had the party to find out whether or not these witnesses that you're going to put in front of this jury were actually at a party at Katie McSherry's house, and not do some background checking on Katie McSherry to see if she has some incentive to testify for the state of Ohio, then I don't know how more ineffective you can be, because Katie McSherry became the key witness for the state in rebuttal. The state didn't know about her until the day before she testified. The defense obviously acted like they didn't know about her the day she did testify, because he objected to her testifying. It was overruled, and then the defense didn't even ask for a short recess so he could do a background check. I mean, at the least you could ask a witness is, are you expecting anything for your testimony? Why do you have an ankle bracelet on your leg? Is there some reason that you have an ankle bracelet on your leg? I don't think that's an improper question to ask the key witness in rebuttal for the state of Ohio. Now, the state wants you to believe that Mr. Liu is an expert on DNA, and yet Mr. Liu testified at the post-conviction hearing that he did not think that those condoms would have any evidentiary value if they were recovered, because he said that there would be no identifiable DNA on the condoms. But he didn't consult an expert to find out whether or not there would be DNA in the condoms. And that would be important for the jury to know. Who cared? This is a red herring about whether those condoms were used for anal sex with his wife. The condoms were recovered. She was never asked about anything regarding her use of condoms with her husband, because she testified that they didn't use condoms. This was just something that Mr. Liu threw out to try to justify his not contacting an expert regarding DNA in the condoms, which Mr. Liu didn't know about, and if Mr. Liu didn't know about it, certainly a jury didn't know about it. Thank you very much.
Thank you both for your presentations today. The court will take the matter under advisement, issue a written decision which will be mailed to both sides, posted to our website, and at the Supreme Court as well.